the Child Care and Protection Act. Section 18, extension of power to take statement of child. Subsection 1. Where a justice of the peace is satisfied by the statement of a duly qualified medical practitioner that the attendance before a court of any child in respect of whom any of the offenses mentioned in the second schedule is alleged to have been committed would involve serious danger to the life or health of the child, the justice of the peace may take in writing the deposition of the child on oath, and shall thereupon subscribe the statement and add thereto a declaration of his reason for taking it, and of the date on which and the place where it was taken, and of the names of the persons, if any, present at the taking thereof. Okay, so that means if a child in a hospital or at home sick, the doctor can say he can't go court, so the JP can take a statement on oath from the child and then carry that statement to the court instead of the child attending the court. They can make that arrangement. Subsection 2. The justice of the peace taking any such statement shall transmit it to with the justice's declaration, A, if the statement relates to an offense for which any accused person is already committed for trial, to the proper officer of the court for trial at which the accused person has been committed. That means the person accused already in front of the court. And B, if any other case, any other case, to the clerk of the court before which proceeding are pending in respect of the offense. So if the person not there before the court already, a trial before the court, then they take it to the clerk of the court. But if the person already a trial for an offense, they can take the statement from the child to the proper officer of the court. Alright. Section 19. Admission in evidence of deposition of child. Where in any proceedings in respect of any of the offenses mentioned in the second schedule, the court is satisfied by the evidence of a duly qualified medical practitioner that the attendance before the court of any child in respect of whom the offense is alleged or has been committed would involve serious danger to the child's life or health, any deposition of the child taken under Part 2 of the Justices of the Peace, the Jurisdiction Act, or under this part of the Act, shall be admissible in evidence either for or against the accused person without further proof thereof, if it purports to be signed by the Justice of the Peace, or by or before whom it purports to be taken. So once the JP signed the document that this is the statement of the child, then that is enough. You don't need no further proof. So whether the statement support the accused or is against the accused, right? What you need is the doctor's statement if you say the child sick and can't go court, and the justice of the peace taking the statement of the child and putting his or her signature on that document. All right. Provided that the deposition shall not be admissible in evidence against the accused person unless it is proved that reasonable notice of the intent to take the deposition has been served upon him, and that he or his attorney had or would have had, if he had chosen to be present, an opportunity of cross-examining the child making the deposition. Okay. So you must give the child notice before taking that statement. Right? All right. Now, Section 20. Evidence of child of tender years. Subsection 1. Subject to subsection 2, where in any proceedings against any person for any offense, any child of tender years called as a witness does not, in the opinion of the court, understand the nature of an oath, the child's evidence, though not given up an oath, A, may be received if, in the opinion of the court, the child is possessed of sufficient intelligence to justify the reception of the evidence and understands the duties of speaking the truth. So a child of tender years wouldn't take oath, but if the court is satisfied that the child of the knowledge and intelligence about the situation, that they can give a statement. B, if otherwise taken and reduced into writing in accordance with the provisions of Section 34 of the Justice of the Peace's Jurisdiction Act, or of this part, shall be deemed to be a deposition within the meaning of that section and this part, respectively. Subsection 2. Where evidence admitted by virtue of this section is given on behalf of the prosecution, the accused shall not be liable to be convicted of the offense unless that evidence is corroborated by other material evidence in support thereof, implicating him. Okay, so the court can't convict somebody based on just what the child said. They must have other information that support what the child says. All right. Subsection 3. In this section, child of tender years means a child under the age of 14 years. So up to 13 years, that is a child of tender years. Or in other words, as it says, under the age of 14 years.